Hello and welcome to Rajya Sabha Television. You're watching The Big Picture with me, Frank Rausen Pereira. Mounting pendency of cases from the Supreme Court to the lower courts has Vice President M. Venkaiah Naidu worried as he expressed concern on the issue. Vice President Naidu also urged the government and the judiciary to ensure faster justice. He was addressing the Platinum Jubilee meet of Dr B.R. Ambedkar College of Law, Andhra University, on the occasion of its 76th Foundation Day last week. Vice President Naidu underscored the need to make delivery of justice speedier and affordable. Citing adjournment of cases over long periods, he observed that justice was becoming costly and referred to the well-known proverb, "Justice delayed is justice denied." In a significant statement, the Vice President remarked that public interest litigations should not become private interest litigations for personal, pecuniary and political interests. In this edition of The Big Picture, we will analyze the issue of pendency of cases and the role of virtual courts. Joining me on the program today are P.K. Malhotra, former Secretary, Ministry of Law and Justice, Satya Prakash, Legal Editor of the Tribune, and Piyush Singh, Advocate of the Supreme Court. Thank you to all my guests for joining me on this edition of The Big Picture. So, Mr. Malhotra, I'd like to start the program with you. First, this issue of pendency of cases is not a new one. Several measures have been tried, tested, everything has been done to try and bring down the pendency of cases, but it keeps increasing. What is the crux of the problem? How do we address it? What more can be tried, do you think?
I think the concern expressed by the Vice President of India in his address is very valid. And if I'm talking about the pendency, I think the pendency, of course, he has rightly said, is increasing in spite of the best efforts made by the government, as well as the steps taken by the courts to reduce it. Let me give a little background of it. As per the latest data available on the National Judicial Grid, as on today in the Supreme Court, there are more than 60,450 cases which are pending. In the High Court, there are 12,800 cases pending, and out of which about 85% cases are pending for more than 1 year. And similarly, in the district and subordinate courts, 2,89,96,000 cases are pending, and 80% of these cases are pending for more than 1 year. Now, to dispose of these cases, if we are talking about the strength of the judges, you have 34 judges in the Supreme Court. You have 1,079 sanctioned judges on the high courts, out of which about 390 posts are lying vacant. And in the district and subordinate courts, there are 22,677 judges, out of which about 6,000 posts are lying vacant. And this problem of vacancy of judges is a permanent feature because of the delay which is taking place in appointment of judges. Now, one thing is that the judge population ratio in our country, in spite of the best efforts, has not increased to the desired level as it is in the developed world or in other advanced countries. I think that is one area which need to be looked into. But efforts to reduce the pendency in the courts have not brought result. And what are the efforts? Let me first list that. The efforts are, we have improved infrastructure in the courts, right from Supreme Court to the lowest court. The infrastructure has been increased. Then we have the in-service training and orientation program for the judges to acquaint themselves with the latest development of the law and the new laws which are coming up. Then use of information technology, which we are doing right from mid-90s, that has not brought the desired result which was expected. And more particularly, the stress is more on ADR than on the reduction, than on the proper litigation in the court. In spite of all these steps taken at various levels, we have not been able to reduce the pendency. This COVID-19 situation, I think, has come as a blessing in disguise, in the sense that use of ICT in the courts earlier was basically computerization of the court, listing the cases as per on the computer, maybe posting the judgments on the internet. People were confining only this. Filing of the petition was also done on the network. But so far as the hearing of the cases in the court was concerned, that was not taking place. Most of the advocates were reluctant for hearing of through video conferences or through virtual court. Similarly, the kind of confidence which should be generated among the litigant so far as the functioning of the virtual court is concerned, because of the glitches in the technology, I think that was another factor because of which it was not taking place. But I think to this opportunity, new opportunity which the judiciary has grabbed, and the Supreme Court after the COVID-19 passed an order under Article 142 of the Constitution mandating all courts, including the High Court and the District Court, to frame the guidelines under which the virtual courts can take place and hearing can continue even in this COVID situation where physical distancing or social distancing became very important so that the courts are not crowded and the spreading of the disease can be contained. So I think these are the steps which are now being taken under the information and communication technology by holding virtual court. Maybe for the time being, they are meant only to deal with the COVID-19 pandemic. But I think with that kind of acquaintance which now the judges have acquired, the advocates are also appearing through virtual courts. A time will come when most of the cases which are either repetitive in nature or say remand cases, family court cases, motor vehicle cases, all these cases can be heard through virtual courts, and which is only very important cases where recording of evidence is very important or some very important constitutional cases are involved. Probably normal physical courts functioning will be required. So I think this virtual court has come as a big boon to all of us, which will definitely help us in reducing pendency by use of artificial intelligence, as well as by saving the time of traveling of the advocates, because sitting in the comfort of their house, they can argue cases not only in one court, but maybe in 2-3 courts on the same day through the use of information technology.
Okay, talking about use of information technology and virtual courts, let me bring in Piyush Singh into the picture. Piyush, what has your experience as an advocate been as far as virtual courts are concerned? What is it that members of your fraternity are saying about the use of technology and virtual courts?
Frank, there has been mixed opinion so far. So as Mr. Malhotra has rightly pointed out, that initially the fraternity, the legal, especially the lawyers, I would say resisted for virtual courts throughout before the COVID-19 situation. But I would frankly admit that it has been a blessing in disguise for most of the lawyers for two primary reasons. One is accessibility to all courts throughout the country. So I can appear sitting in Delhi in a matter which is in Bombay High Court, also in Kolkata High Court, or maybe in a district court in Trivandrum. So all that accessibility to justices has come. Also for the clients, I would say there used to be clients who used to travel for every date of hearing from different parts of the country for a particular date of hearing, and that matter may get adjourned, the matter may be heard or may not be heard. So I would say for all the three pillars, for the judiciary also, it has turned out to be very convenient, because even then our court files have been digitized, and for the judges also. So I would say for everyone, the system so far has been very convenient. Definitely there are technical glitches for now. So if I have to give you examples now, before the Supreme Court, the video app the Supreme Court is using, it functions pretty well. But today itself, there were some news articles circulating regarding today's hearing before the Supreme Court, which was a constitutional matter, in which some of the senior advocates were muted, I would say inadvertently, by the Supreme Court staff. So by the time the matter got over, they couldn't speak anything, or they couldn't be heard by the bench. So these are some technical glitches, of course, which with coming times, these can be taken care of. Definitely network issues are one. In a country like ours, there can be serious, I would say, internet network issues. But otherwise, it has, I would say, has taken a very wide acceptance. But definitely, I will also want to point out that majority of lawyers, it's not only lawyers, there are also members of the judiciary, especially subordinate judiciaries, who are not well versed with operating a machine or operating a computer. So they need to be, in this situation, they were aware how to, I would say, open a Word document, PDF document, how to write an email. But it was very different how to share your screen while arguing, or how to look into a document simultaneously when you're also hearing the argument. So there were some certain issues which had come up, which are still there, which are very serious issues. And secondly, also there was an apprehension initially that how things are going to turn out, because there used to be in usual court hearing, there used to be an arguing counsel used to get an opportunity to interject or to offer arguments during the counter arguments. So there used to be several aspects, or I would say the beauty of arguments which used to be there, which lawyers used to always enjoy. So that fun may be missing, but I think more than the fun right now, the time is to evolve. The time is to accept the broad changes these times have brought in. But interestingly, Frank, I need to just make one point here, that in a situation like social distancing and COVID-19, and also for the future times, this is a very convenient system, virtual courts. But to link it to pendency, I do not see any interlink between virtual courts and pendency, because the same time frame which for an open court hearing used to take, the same time frame a virtual court hearing, or I would say maybe more, the virtual court hearings are taking. So now, in case the court used to function for 8 or 10 hours, the same functioning is happening now. So definitely the problems highlighted by Mr. Malhotra for which were for pendency, which were there, maybe shortfall of or vacancy in the judicial system, number one. Number two, huge importance has to be laid on adjournments. We get adjournments in India, and especially in the courts, especially in the lower courts, at times in the high courts, for any frivolous reason. You can have, there is a strike in western part of Uttar Pradesh. For last 30 years, there is a strike on Saturday. No judicial work is happening on Saturdays for last 30 years, just because they want a high court in the western part of Uttar Pradesh. Now, can you imagine this kind of situation we are facing? So, at least 20 districts of the western Uttar Pradesh, they are having a strike for last 30 years, and matters are getting adjourned. One day of a week, there are no hearings. So these things cannot be addressed by virtual courts, but definitely, I would say it's a very welcome move, and the fraternity for now, I can't speak for all, but yes, they definitely have challenges, but yes, the fraternity has definitely accepted it in good zeal.
Okay. So, all right. So, Satya Prakash, you heard both the panelists before you. They're both saying that this is indeed a blessing in disguise. But yet there are several members of the bar who, in fact, have been talking about, who approached the Supreme Court and others saying that, the courts or the doors of the courts should open as soon as possible. So clearly they too are trying to make a case. So what are your thoughts on this?
Well, before I articulate my thoughts, the Bar Council of India, which regulates the legal profession in India, the Supreme Court Bar Association, and the Advocates on Record Association, all three major bar associations in Delhi, they have requested the Supreme Court to go for physical court hearing as soon as possible. In fact, Bar Council of India went to the extent of saying that because of the virtual court system, the entire system is being hijacked by a small group of lawyers, and they said 95% of the lawyers are going to become briefless. So, to my understanding, this COVID-19 situation has exposed the digital divide in the legal profession. There are people who have access to all these gadgets. They can operate these gadgets, and hence they can access the court. There are others who simply either they don't have the gadgets, or they have the quality of gadgets and the Wi-Fi connection or the internet connection is such that they cannot access the court. So this has exposed the digital divide in the legal profession. In fact, Bar Council of India tried to address it by having some arrangements where they provide the basic gadgets to lawyers to approach the court. So they tried to solve it to the extent possible, but it's not practically feasible to provide electronic gadgets to thousands of lawyers in Delhi, or maybe lakhs of lawyers across India. So this has to be worked out. But having said that, this is a completely different situation. We are in a crisis situation, so we need to fall back upon technology, and to the extent possible, the Supreme Court and the High Courts, they have, and even trial courts, they have tried to use technology. But I'm sorry, judiciary has been a very slow learner. I'm not talking about judges or lawyers. I'm talking about entire institution. Judiciary has been a very slow learner, and Mr. Malhotra has been part of the system, the government. He knows how it started in the early years of this millennium. Around 2005 or 6, the entire program to digitize the entire system and interlink the entire judicial system that started, but they still has not been completed. One second, even the basic things like e-filing, even that has not taken place. Like in the year 2017, Justice J.S. Kher, who was then Chief Justice of India, he declared that after a couple of months, it's going to be all paperless court, at least the Supreme Court. It didn't happen. Still, papers are being used. And even so, these are the basic problems. To some extent, it's the problem of infrastructure being created by the government and the Supreme Court together. And second, at some level, there is also a question of mindset. There is a generation gap between the judges and lawyers. The younger judges who are pretty well versed with all these gadgets, barring a few, the older ones, they are not comfortable. Second, even in the legal profession, the youngsters, they are pretty well versed in all these gadgets, and they know how to use it, as Mr. Piyush was explaining, how to use it, how to share a screen and all these things. For the youngsters, it's very, very comfortable. And some of the older people from older generations, they also know how to operate it. But at the larger level, if you talk about judiciary in general across India, and bulk of the pendency is there in the trial courts, if you want to address that, this digital divide in the judiciary has to be addressed. Unless that is addressed, in situations like this, the pendency is going to multiply and we cannot help it. So that problem has to be addressed, and unless that is addressed, we can talk about it, but the problem will persist and then it will get worse.
Okay. We spent a lot of time in our opening remarks. I'm going to ask the panelists to be brief in the next round so that we can have concluding remarks as well. So talking about solutions, talking about ways forward, talking about dealing with this issue of pendency of cases, Mr. Malhotra, there have been several people who have, given their advice. Some have suggested that the retired judges can be called in, maybe to try and hear some matters and dispose of them. There are some other people who have said that the retirement age of the judges need to be extended so that they can work for a little longer and dispose of cases. What do you make of all these suggestions? Do you believe that it is workable? Do you believe that the kind of pendency of cases that we have, it can be addressed with the measures like this?
I think these measures are definitely important and these measures can be taken. But as Satya very rightly said that we are slow learner. In addition, I would say not only we are slow learner, but most of us are status quoist. We don't want to change the existing situation. That also creates a problem. Piyush also mentioned about the frequent adjournment granted by the judges or the frequent adjournment sought by the advocates. If you look at the provision of the CPC, a specific provision was made way back in 1992 that the court will not grant more than 3 adjournments. In case they are adjourning more than granting adjournment, more than 3 adjournment, then cost will be put on the party who is seeking adjournment. But this practice is also not being followed strictly. If we strictly follow the spirit of the law, probably many of the problems can be looked into. Yes, increasing the strength of the judges is one area. Use of the technology, as Mr. Satya also pointed out, yes, it is important, because even I remember Justice Chandrachud, who is heading the E committee, who is the chairman of the E committee in the Supreme Court, while addressing a webinar to the students in the Nalsar University of Hyderabad, he also has said, I don't think virtual courts are going to replace the open court hearing. The moment you are mixing that two, and if you don't make use of the technology, then only all the problems start. Yes, you cannot undermine the importance of the technology in the day-to-day use of the court proceeding, and it has definitely brought the improvement in the judicial system or the justice delivery system. Take, for example, if a judgment is delivered, say, running even into 1500 pages. Earlier, if you have to get a copy of the judgment, it will take months to get that copy. Today, the moment judgment is pronounced in the court, the very next moment, the judgment is available on internet. Similarly, what is the status of your case? If you just open the computer, you can find out what is the status of your case. I think definitely the technology has brought improvement. It has made justice more accessible. But yes, the kind of digital divide which has been created, that is only because of the technical problems which we are facing. So whatever technical glitches are there, in case we are able to remove those technical glitches, Probably more use of technology will definitely expedite disposal of cases also. Take for example, in smaller towns, if you provide a center where advocates and the clients can go and attend the cases through video conferencing, even if they usually don't have that facility, they can use that center for that purposes. So technology can help, addition of judges can help, and implementation of the law in the spirit in which it was enacted will also help in reducing the pendency.
Right. Okay. All right. Then taking the discussion forward, Piyush, let me bring you to the picture. Now, let's talk about the issue of, special courts. There have been several special courts that have been set up across the country to deal with, special matters and to dispose of issues, in a timely manner. What has our experience been as far as special courts are concerned? Have we been able to address the issue of pendency of cases through these special courts? Have they been able to dispose of the cases as quickly as we would have liked them to?
Frank, special courts, be it, I would say, majority of the times in our country have been constituted for the majority of the criminal offences, like quasi-criminal offence like 138 Negotiable Instruments Act, check bounce cases, for POCSO, for child-related offence, any kind of sexually child-related offence, we have special courts. For corruption cases, recently we have different CBI courts. For civil matters, now we have got a different commercial courts being established. Definitely, it has acted, I would say, has created very specialized courts, and it assists in speedy disposal for two reasons. Primarily, usually in any court, previously before the enactment of special courts, for be it the prosecution or be it the opposite side or be it the judge, they used to deal with a variety of cases in a particular day. With the special courts being enacted, these kind of matters are taken up wherein the prosecution is dealing with a very specific kind of a mandate, and the time frame is fixed for most of these matters. So special courts has definitely added to disposal of such cases. There's no doubt about it. And with virtual courts coming in, I would say these special courts can be now one of the biggest advantage for virtual courts is, other than the evidence which needs to be laid, evidence and cross-examination, though there has been advice, then even that can be with artificial intelligence and machine learning coming in. Even the evidence can be taken virtually, and it can be absolutely as seamless as it is done in day-to-day hearing. But I would say that may take some time. But with virtual hearings, even the special courts can be, I would say, be very well equipped to deal with the pendency. There's no doubt.
Okay. All right. Let me bring in another aspect in now. Satya Prakash, let's not forget PILs and government litigation as well. They too seem to clog up the courts. How do we deal with that aspect?
Well, it's very difficult. It's to some extent the problem has been created by courts themselves. There are two, three things. One is so far as the constitutional setup is concerned, if you have a constitution that guarantees a set of fundamental rights and also provides for constitutional remedies for realization of those fundamental rights, I'm talking about Article 32 and 226. If somebody's fundamental rights or in case of 226, even statutory rights are violated, there are people can go to courts directly, either Supreme Court or High Courts. Having said that, there was always a question of locus standi. Who are you? Why have you come to the court? In the Supreme Court in the early 80s, they diluted the locus standi, and they said, if somebody is coming to the court bona fide on behalf of the poor and downtrodden, those who cannot approach the court directly, in that case, that person can be entertained. And since then, we are facing this sort of barrage of PILs across India in all the high courts and Supreme Court. In Delhi High Court, when I used to go there regularly as a journalist, there used to be Wednesday used to be the PIL day. So there are days where important benches, but maybe mostly headed by Chief Justice or maybe the J1, the number 2 judge. So now it is becoming a problem because there are cases where you can easily make out this is simply filed for publicity. So PIL has become to some extent publicity interest litigation, in some cases even pecuniary interest litigation. So this has to be checked, and there are Supreme Court verdicts, and the courts have to apply some sort of some sense of proportion, because you can easily make out there is one person who has filed dozens of PILs in one court. So you can easily make out how can that person, and that person is not a social worker. So then it is for courts to exercise restraint and apply some sort of checks and balances so as to weed out that kind of PILs. And genuine PILs must be entertained, while the frivolous ones must be curtailed, even if the courts are forced to impose heavy costs or fines on the petitioners. That must be done, because the court time is not meant for all these things. It is meant for the genuine litigants. If you spend much of time on PILs, then the genuine litigants, they suffer. So it has to be checked. There is no two-way. I'm saying it because why? Because there is a study conducted by the National Court Management System of the Supreme Court itself. The study was conducted in 2012, and the study says as the literacy rate and the income standards go up, the number of cases being filed in the court system will drastically increase. And in the next 3 decades, the study says it will have around 15 crore cases. Today we have between 3 and 3.5 crore. It's going to be 15 crore cases requiring 75,000 judges. Currently we have around 20,000. So the system must be augmented, both in terms of manpower and infrastructure. And second, even the existing system must be used to the benefit of the genuine litigants. So this PIL part, as you said, and the Honorable Vice President has also said it, that frivolous PILs must be curtailed, and the courts should impose heavy costs on them.
Right. Okay. Quick closing comments now from all my guests in 30 seconds each, with the best way forward, starting first with you, Mr. Malhotra.
Well, as Justice Satya said, so far as PILs are concerned, it is a must. You cannot avoid PIL. What need to be avoided is frivolous PIL, and that can be done by the court themselves. If they are imposing a heavy cost, it can be avoided, as Mr. Satya Prakash has also said. Virtual courts are going to stay, but only thing is, all cases cannot be conducted through virtual courts. It has to be a hybrid model of virtual court as well as physical courts. Technological glitches need to be sorted out so that digital divide can be avoided, which is existing as of now, because the virtual courts have started because of COVID-19, which is a temporary phase and working under an order passed by the Supreme Court under Article 142 of the Constitution. But if it has to stay, then we have to ensure that people living in the remote area also get access to the courts through virtual courts at the centers to be established by the government. And obviously, the judge population ratio need to be increased, and vacancies must be filled up as expeditiously as possible.
All right, Piyush.
Frank, the disruption is not by COVID-19, disruption is by the technology, which we are not ready to embrace. So this disruption, I would say we should welcome for technology, and we can't say that we do not have enough infrastructure, or we do not, or the older generation is not aware how to use the laptops. Even the doctors were not used to wearing PPE kits and operating, and for working for 8 hours wearing a PPE kit. So everyone during these times of disruption with technology, everyone, I would say, have evolved, and everyone has embraced technology. And the sooner we do it, the better it would be for the system and for the country on a whole. Number one, with respect to technology, this would be closing remarks. Fine.
Okay. Satya Prakash, close the show for us.
Well, at a time when technology should be seen as a solution to the problem, it's being seen as part of the problem by a section of the legal profession itself. Bar Council of India, Supreme Court Bar Association, and even Supreme Court Advocates and Reporters Association. In particular, Bar Council of India is resisting. They are saying go back to physical court hearing even during COVID-19. So this is, and their problem is that the large number of advocates, they are not equipped with these devices. So there is a digital divide that needs to be addressed. One. Second, as Mr. Malhotra has said, the number of judges, it has to be increased. There is no way we can handle the pressure without increasing the number of judges. For that, first, the existing vacancies must be filled. That's the first. Unless we do that, the problem will get, it will get worse in the coming months.
All right, then, with that, I'll call it a wrap on this edition of The Big Picture. Thank you to all my guests for joining me on the program and putting things into perspective for us. What's coming out of this discussion is that despite several steps taken by the government, pendency of cases has not come down. The pandemic has come as a blessing in disguise, as it has posed a new opportunity to use technology which will help in dealing with pendency of cases, what the panelists are suggesting. There is no direct correlation between pendency of cases and virtual courts, is what the advocate on the panel is suggesting, where virtual hearings take the same amount of time as normal hearings. Meanwhile, third panelist has suggested that COVID-19 has exposed the digital divide in the legal profession, and this is something that we need to work towards in the near future. We also have to ensure that appointments of judges across the country is taken care of, and we have the maximum strength if we have to deal with pendency of cases. With that, it's a wrap. See you again next time.